You are here?
Yes, madam.
All right.
No more further technical claims.
Is it only for this matter or for some other matters?
matter.
For this matter. Nice that you came here.
Look, I am filing affidavit in reply against the.
Yes. You could have brought Mr. Kumar with you. Both could have enjoyed here.
Not told me anything, my lord. Without informing me, brothers.
Administrative cause. Yes. What happened?
My
The
lord,
order not
they
complied?
failed to comply, my lord. My lord, my respective submission is that they approached the Honorable Apex Court against your lordship's order. That was dismissed. Thereafter, my lord, they passed an order to circumvent your lordship's order. They reduced the amount. My claim is 6,13,500. They paid me only 47,000.
Only 47,000?
Yes, my lord. My lord, I want to go to the order, my lord. Kindly come to my lord. Affidavit of complaints filed by them. Page 6.
Yes. Yes.
Page 6, my lord, para 3. According to the petitioners, the appellant will not be entitled to reimbursement of the medical bills. The office memorandum dated so and so by the Ministry of Health and Family Welfare, Government of India, has been relied upon to reject the claim of the applicant. It has been submitted that there is no provision for reimbursement of medical bills of a pensioner. My lord, kindly take a note. They say that there is no provision for claiming medical bills. Now they are relied upon. Kindly come to page 74.
Yes.
74, my lordship, kindly see the total amount. Last, it is there, my lord, total amount 6,13,000. Got it, my lord?
Yes.
Now, kindly see grand total. The amount paid to me, this much.
44,708.
Yes, my lord. Now, my lord, kindly come to once again to the order passed by your lordship. The main, only operative portion I will relay. Page 8, para 7 of the order passed by your lordship.
What is this non-NABH?
They say that they under the scheme, it is coming. The scheme is at this page 13. The first page is at page 13. Under this scheme, they paid the amount, whereas they say that for the petitioners, there is no provision for reimbursement. If there is no provision for reimbursement, they cannot rely upon any scheme. I am not coming under any scheme.
But the issues are.
Please wait, please wait. My lord, I am aged about 76 years. I am litigating for the last 10 years, my lord. This is a referred case. I went to GP Pant Hospital. There is no treatment available in GP Pant Hospital. I was referred to mainland. It is there in the order itself. Now, my lord, kindly come to the order. Paragraph 7. Last 3 lines may be seen, my lord. Entire amount was given for all cases. In para 8 also, there is a judgment of the Honorable Apex Court. My bill was verified by them, my lord. Kindly come to my affidavit file today. It was verified by the head of the department.
And the bills that you raised,
My lord.
was it certified by the hospital where you...
Yes, my lord, page 8. It is there in the order itself, my lord. It is certified. My lord, it is at page para 9. It is there. My lord. I am reading, my lord.
Yes,
Upon
9
hearing,
I have read the bills of the original record. All right, let me hear. Yes,
My lord, may kindly come to page number 9, my lord, para 10.
yes,
12 is the operative part, my lord. My lord, as the issues was that not the retired government employees is entitled for medical reimbursement or not. My lord, while passing a judgment, specifically held that they also to be treated at par with equivalent with the regular employees because they are also entitled for medical reimbursement. This,
yes, then.
this was the decision my lord has passed, and my lord has specifically directed to verify the bills and release the reimbursement has to be given to the petitioner. My lord, we have, that is my lord, page number 74 in the tabulation.
Yes,
My lord, the hospitals which he has taken treatment, that is my lord, non-NABH rate. My lord, this is a tariff which is notified tariff by the government of India with regard to the medical reimbursement. Based on the tariff rate and as well as the serial number we have specified, my lord. That's why on earlier date I said, my lord, because there isn't any calculation or anything wrong which based on this they can point it out to us, we will rectify this. My lord, the instant reply I perused filed by the petitioner, they want 100% reimbursement should be paid. This is what they are claiming now. That the treating should be as a special case, he should be released with 100% medical reimbursement.
listen, thing is, had the medical facility been available in Port Blair itself, then the patient would not have been forwarded to Chennai for treatment, isn't it?
Yes, my lord. All the patients who have been referred to Chennai based on the tariff rate which is notified only, they have been reimbursed, my lord. Even this person, as my lord has given reference regarding
Yes.
Abraham, that is page number 8. I can, if my lord was, I can produce his amount which he has been paid. He has been paid in terms of the same tariff rate. And he subsequently went to the tribunal. Tribunal officer said,
Did you disclose your tariff rate?
yes, my lord, I have enclosed tariff rate, my lord.
Where is your tariff rate?
Yes, my lord. My lord, may kindly come to
start from page 13.
30 is the National Aggregated Board Hospitals, my lord, the names of the hospitals, and page number
13.
Why did you refer the petitioner to a hospital where the tariff is not admitted by you?
is we are not referred, my lord. He has referred himself went to that hospital for treatment.
How can that be? If the medical facility was available in the hospital at Port Blair, there was no question of forwarding him to GB Pant Hospital.
Hospital, we are not referred, my lord.
No, referred. My lord,
Referred for further medical treatment at mainland.
Get page 10 of my affidavit.
Come to see page 10.
Page 10 of my affidavit. Second page, my lord. Page 11, it is there. My lord, it is recorded in the order itself.
Further treatment be done in the dental clinic in the mainland.
Yes.
We have not referred to any particular hospitals, my lord.
Facility of implants and bridge is not available in GB Pant Hospital, dental department. Further treatment is to be done in dental clinic in mainland. It is a referral. And my document.
But then tell me, if it is a referral, can you get yourself admitted in any hospital you choose, or you have to get yourself admitted in a hospital?
Any hospital like
Where is that provision that you can go to any hospital? See, here also, if you take insurance, then you have to have a coverage which is reimbursable by the insurance company. You cannot go and have treatment anywhere else, and assuming you go, your limit will be restricted to your insurance. The premium
I'm not
that
coming under that scheme, my lord.
yes. So what is your scheme? Does it mean you
I'm
can
not coming because I'm pensioner. Pensioners, if I pay monthly subscription to the scheme, then only I'm coming.
any hospital you can choose?
No, my lord, that is why
Any hospital you can choose, my lord. Kindly come to the para 7 of your lordship's order. 7, 8, and 9. The picture will be clear. In all cases, my lord, earlier cases, entire amount was given.
no, my lord, as
Entire amount
Yes.
in accordance with the rate that they
That's not applicable to the pensioners. They themselves they say before this honorable court.
no,
Kindly come to
the brother is
para 3.
my lord.
Para 3.
Hmm.
Para 3, my lord. According to the petitioners means the
Yes, you.
government.
Hmm.
The appellant will not be entitled to reimbursement of medical bills. The office memorandum dated so and so, the Ministry of Health and Family Welfare, Government of India has been relied upon to reject the claim of the applicant. It has been submitted that there is no provision for reimbursement bills of a pensioner.
Hmm.
The issue, my lord. My lord has clarified that they
There
are
is no scheme for the pensioners.
All right, but assuming you are a member of the health scheme, then how much are you entitled for
If I am
reimbursement?
coming under the scheme, then page 13 is applicable. Page 13, the scheme.
Show me the scheme once.
My lord, it is there, page 13 of the affidavit of complaints.
No, these are the hospitals possibly. Where is the scheme pursuant to which this reimbursement, if any, you will get? Where is that scheme?
Scheme, I am not coming under the scheme.
Lord,
Pensioners,
in order to clarify the position, because their only apprehension was in persons to para 7 and para 8. The petitioner, those who are in para 7, the writ petition, and the petitioner who is in para 8 of the writ petition has been paid full medical reimbursement. That is absolutely wrong, my lord. I can produce the order because when they file an exception to the report, immediately ask the authorities what is the status of with regard to para 7 and para 8 of the petitioner, those whether they have been given full reimbursement or not. They said no, they are not given full reimbursement. As per the notified tariff by the Government of India, their cases have been assessed, they have been paid with the medical reimbursement.
Tell me one thing,
Yes, my lord.
Mr. Kumar.
Yes, my lord.
According to you,
Yes, my lord.
is the pensioner under any health scheme or anything of that sort?
No, my lord. Here the question was, my lord, as per the Government of India decision that the pensioner is not entitled for medical reimbursement. They went to the tribunal. Tribunal has said to consider, because already several litigations the court has decided that they are entitled for medical reimbursement. My lord has also said that in terms of the previous orders, so this court has not find any intervention with the claims of the respondents. So this court has affirmed it. Even Supreme Court has also affirmed it that there should be treated at par with the regular employees, because whatever the reimbursement regular employees are entitled, they are also entitled, my lord. As
So
such,
what is the regular employees entitlement? Have you
that is what-
disclosed?
yes, my lord. My lord, 74, my lord, third line.
Yes.
May permit to read, my lord, in accordance with the provisions contained in Rule 6.2 of CCA MA Rules 1994, all the instructions contained in Government of India, Ministry of Health and Family Welfare, OM dated 18/6/19, also obtaining concurrence on the finance department. My lord, this is the rules under which the medical reimbursement has to be paid, and the rate which is relied by the authorities are the current rate, my lord, which is at page number 25. Page number 25, my lord. If my lord will see top, my lord, the CGHS Chennai rate list 2014 updated on 5th February 2024.
Right.
There are two slabs, my lord. One is non-NABH, one is NABH. The rates which is NABH will be higher because there is a notified hospitals. If the rate is non-NABH is not a notified hospital. So he has taken treatment in not a notified hospital. So as such, the value of the ratio is come a lot. So he has been reimbursed based on this one.
If you take the non-NABH rate, how
Yes,
much is the petitioner
page
entitled
number
to?
74, the details have been given. Madam. Page number
44,708.
74, madam. Page number 74.
Yes, 44.
Rates have been quoted, madam. Non-NABH rate.
That means 44,708.
Yes, madam.
for implant, my lord, clause E, nothing was paid. 0.
For implant clause E.
Lord, in the rate
What
list,
is your rate in implants?
Lord, it shows not NA, not available, madam. In the rate
That
list.
means not non-available because this facility is not there in the government hospital. That is the reason it's not available.
Lord, in NA, the rate list, it shows NA, my lord. That's why we have quoted in the order also that it is
No, it should be something because this is the highest figure that the petitioner has claimed.
3
And
lakhs 60,000, my lord.
implant has been done. not that the petitioner has not done the implant. So in that case, you are required to pay something for the implant. Had the petitioner been an employee of the government and not a pensioner, then what would you have paid?
But I don't know what my lord is saying, but the rate, it is not in the rate list because there is a non-NABH. So as said, they have been given as 000.
No, that cannot be. If a central government employee requires an implant, then you are bound to pay something.
Not the rate list.
No, your rate list will not do. You have to find out the figure. What you were supposed to do exactly
Yes, madam.
was just verify the bills
Yes, madam.
submitted by the petitioner as to whether the figures are proper or not.
Yes, madam.
And you were required to pay. You went to pay only 44,000 when the claim is 6,13,000 and odd. This cannot be permitted.
But because as the tariff list, it has
No, no.
if Milord is saying that it should be an exceptional cases, then we have to bound Milord because it will be treated in other cases if it is other cases also same rate list has been applied as per para 6 and 7 as Milord has quoted. They are also been paid in similar manner, Milord. That's such I made these submissions, Milord.
My lord, one document I would like to submit. My affidavit, my lord, page 8. It was verified by the HOD, dental department. This is the judgment, my lord, based on
And see the certificate at page 8, which the petitioner has annexed in the affidavit of reply.
Yes, Milord.
This is signed by the head of the department of the dental department of ANIIMS Port Blair. And he says, and it is found to be genuine and recommended. So he also recommends it.
We are not denying it, Milord. Is because he has done the treatment. Even in page 74 also we have mentioned that. If Milord,
Yes.
the bills have been mentioned that. I cannot go beyond the records, Milord. We mentioned. But the only difficulty is, Milord, it has to be paid in terms of the rate list, which is because the
No,
medical.
if you have such a rate list which is unworkable, then what will the employees do?
Milord,
And moreover, the petitioner is a pensioner. He is litigating for the last 10 years, it is claimed. Then
now I am
I
76. now.
just,
76 years old man.
Milord,
Show
then,
some respect to the age.
Milord, then I request Milord may pass an order. Milord, treated this should be exceptional cases for considering it for these medical reimbursement. Milord, because
Uh,
Milord has said so that can based on that order we can pursue and we can release because it should not be treated as precedent to other cases, Milord.
Regarding the certificate,
You mean to say for the petitioner, the rate will be different, and for somebody else, the rate will be different?
No, Milord.
Then
I
you
said
are required to um, fix up a rate
yes,
which
Milord.
is in accordance with the prevailing market rate. You cannot see the bills that you have annexed, page 74 or something.
Se- 74 is
500
a sanction
rupees.
order, Milord. Order.
When the rate you have mentioned is 500 rupees, the claimed amount is 10,500 rupees. How can there be such a lot of difference?
But this
In
is an
fraction,
update, as I
you
said.
give 1,680 and the petitioner has been charged 16,800, 10 times more. How is it possible?
It is a non-NABH rate, Milord, because he is not went to treatment in a recognized hospital. That is a difficulty, Milord. That has been slapped at page number 25. That's why the rates are. That's why his claims amount has been reduced to that extent, which is permissible in terms of the page number 25, Milord.
You please revise your rates properly so that the petitioner is paid.
Milord, it is central government agencies, Milord. They have been fixing the
Different.
rates.
So that are annexed at pages 25 and thereafter,
Yes, Milord.
the rates, the difference is not much. How come the petitioner claims 10 times? I do not know. And your head of the department recommends it.
Lord, I will file a
Regarding the
additional
certificate,
disclosing the
order also.
Yes, I've checked.
Lord, I just tell the account section once again to verify with regard to the rates, my lord. I will give a short reply affidavit by enclosing.
Please check up the figure.
I will not. So that the court can be clearly access the rates, what is differentiated, what is the norm or rate which has been specified.
Where is the provision for bridge removal in your rate chart? There also the petitioner has claimed 8,000 rupees and you have given 0.
Lord, the rate chart is the same, my lord. It is not.
That means you do not have this provision for bridge removal. That is the reason it is 0.
Yes, my lord.
But if the patient has undergone this bridge removal, then the patient is required to be reimbursed for that treatment. Where is this alveoplasty? Full mouth in your rate chart?
203, my lord.
500 rupees, please show.
My lord, 203, my lord. Page
Alright,
29, my lord. Page number 29. Serial number 203.
203. Pre-prosthetic.
Surgery, alveoplasty, 500 rupees.
And this is possibly you have
500 rupees has been paid.
this is alveoplasty pre-prosthetic, it is mentioned, but then here it is mentioned full mouth and nothing is mentioned about pre-prosthetic.
Lord, I will file an additional affidavit disclosing the rate which includes the treatment what he has done, my lord, so that it can
No,
be.
the rate is here, then what will you add in addition? Do you understand, Mr. Kumar?
Yes, 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 my lord.
The rates
Lord, I understand with regard to the rates of bridge removal and the implant, because these are the two amounts where they have not paid anything.
nothing.
Yes, yes.
Bridge removal and the implant, 0 amount has been paid.
Yes, my lord.
And when temporary complete denture, petitioner has charged 40,000 rupees and you are giving only 1350.
Lord, 211, it is given 1350, my lord. Complete single denture, metal based. 211, my lord, page number 29.
I have seen 211.
Yes, my lord.
Assuming the NABH rate is taken, then also it comes to 1553, not more than that.
Yes, my lord.
Where did you take the treatment from?
From
5-star hotel or what? Then?
Dental treatment is very expensive nowadays. Even for removal of one teeth, they charge 800.
The government is paying 500 rupees.
That is absolutely wrong. And that scheme is not applicable to the pensioner.
No, no, my lord. It is the scheme which has been reimbursed to the regular employees also.
You challenge the order before the Honorable Apex Court. When you fail, you circumvent the order passed by this Honorable Court.
Absolutely not, my lord. We have to, as per the reimbursement, what is the rules we have been paid, my lord, subject to my lord's consideration.
No, your rates are absolutely improper. Page 29, the extraction per tooth, 184. You pay only 80 rupees. Tell me where to get this treatment with 80 rupees.
This
Is it available anywhere? But
It is notified by the
it
government.
is 800 rupees, your learned friend says, and you are paying 80.
Maybe typing mistake. my lord.
Lord, it is been
Cannot be.
notified by the government of India, my lord.
No, no, please, you revise your rate or do whatever you feel like, but then 44,000 is an unacceptable amount. This cannot be done. Isn't it? Please come. Affidavit in reply filed by the petitioner in court today is taken on record. Stop. Learned advocate for the petitioner stresses that the order passed by the court has not been complied with. Stop. The amount claimed by the petitioner is rupees 6,13,500, whereas the amount reimbursed by the authority is only rupees 44,708. Stop. According to the contemner, the petitioner has been paid, not paid, reimbursed the amount in terms of the scheme of the government.
Non-NABH rate, my lord.
Bracket non-NABH rate. Stop paragraph. From the calculation sheet annexed at page 74 of the affidavit of compliance, it appears that the petitioner has not been reimbursed any amount on account of bridge removal and implants. Stop. There has been 12 implants at the rate of rupees 30,500 each. Stop. It further appears from the said calculation sheet that the figures claimed by the petitioner and the one reimbursed by the authority are quite different from each other. Stop. Next. The paragraph there, the authority has to keep in mind that the petitioner was referred to the mainland for treatment only because the treatment in the island was unavailable. Stop. The medical bill submitted by the petitioner was recommended by the head of the department, dental department, caps ANIIMS, Port Blair, way back on 7th November 2016. Stop. Learned advocate for the petitioner submits that his client is nearly 76 years of age and is litigating for the last 10 years for his reimbursement. Stop paragraph. The contemner is directed to revert with further affidavit. Clarifying the position as to why such a meager amount has been reimbursed, even though the medical bill claimed by the petitioner has been recommended by the head of the department. Last is line found to be genuine and recommended by the HOD of the dental department. How soon can you come back?
My lord, if my lord is saying, then 1 second, I check instructions. my lord.
Yes, you please.
Pura payment. Lord, if my lord may kindly clarify the position, my lord, because this should be treated as my lord has already said that it is a retired senior citizen and fighting for this. So one line, my lord, that should be as a special case, it has to be considered.
This special case not to be treated as precedent, all will come later on. First, you say how much you'll pay and whether you pay the whole thing or not, and please
Yes,
finish
yes.
it off.
Yes,
Let
yes.
this person not litigate, take care of his age and
Within
his health condition and finish it off.
within a
Wait
15
one
days.
more day,
Yes,
the
yes, ma'am.
court will permit this matter to go on. Otherwise, no further.
Yes, yes, my lord. Yes.
Today
Sir,
is the
my lord.
22nd of January.
Yes, my lord.
We fix it on the 19th of February. 4 weeks time you get in the meantime.
Yes, yes, my lord. Yes, my lord.
All right?
Obliged.
Released 19th of February 2026.
Oblige, my lord.
It will be nice if you come here,
My lord.
but it is not mandatory. You can join online also.
My lord.
All right.
Obliged.
Oblige, my lord. Am I permitted to leave, my lord?
Thank you. Yes.
Oblige, oblige.
Lordship, may I permit to mention one content application? Today's Delhi list running, Lordship.
Contempt is there in the daily list.
Daily list. But check
So
for
wait, it will be taken up.
Lordship, his petition has mutilated land. Mutilated land is encroached by private respondents. He is physically handicapped. Kindly, Lordship, mentioning for upgradation.
Then
Next Thursday, kindly fix a time, Lordship.
thing is, do you
Already order is compliant here. Alleged contemner is KMC, and order has compliant, and
are you
affidavit of
representing?
compliance has been. Yes, sir.
Who are you representing?
I am for the petitioner,
And you say the order has been complied.
because affidavit of compliance has served to me.
Has the order been complied?
Yes.
Then why are you? I'll dispose it off.
No, matter is running in the list, Lordship.
If you say the order is complied, then what
because
remains?
they have sent a in affidavit of compliance, they have told everything, and they have gone for inspection, but the measurements have didn't taken. Kindly fix a date, Lordship.
Who is your other side?
KMC Ziaur Rahman, Lordship. He is the alleged contemner.
Not the contemner, the learned advocate. Who is the learned
Learned advocate Ziaur Rahman, and Subhashish Das, who is the alleged contemner, executive engineer of KMC.
Ziaur Rahman.
Yes, Lordship.
What the which corporation?
KMC. Kolkata
Ziaur
Municipal
Rahman.
Corporation.
I don't know. এটা কি একটু next দিনকে উপরে দিয়ে দেবেন তো? Yes, on the list.
I was seeking leave to file application relating to determination of circuit.
But then there is a difficulty. The circuit bench, neither the server, nothing is functional right now. আমরা নতুন মামলা নিতে পারবো তো? Even I thought if the bench is not there, then it can be
Yes,
taken up here.
Yes.
But then yesterday only I was told that it is becoming একটু ডেকে নিয়ে আসুন তো, কে বলছে নেবে না তাহলে it will be.
My lord, may I be permitted to mention item number 520 of today's list, my lord, contempt application.
Yes.
My lord, the urgency is that, my lord, the Public Works Directorate were directed to release the dues, but they have not yet released. We have served upon them.
Dues for what?
My lord, the order has not been complied with. The
Dues for what?
dues for, my lord, the tender work, my lord. They have completed the tender work.
Please wait. Please step in.
My lord, in item number 1, the contender in person is present, my lord, and affidavit of compliance has also been filed, my lord.
Yes, petitioner, has the order been complied?
My lord, not my lord. Because
No.
kindly see the order, my lord. Kindly see the order, what my lord has passed the order. It's at page 16, my lord.
Court Blair. Compliance. All
Kindly
right.
check the
Page
compliance,
16.
my lord.
My lord, kindly see page 16, the paragraph 12, my lord. Is the relevant portion of the order, my lord. My lord has passed the order.
Hmm.
May I read, my lord? In
Yes,
view of
yes.
the above, the Tahsildar is directed to conduct a spot inspection upon prior notice to all the necessary parties to ascertain and demarcate the land which has already been acquired. What the contemner has to do, the respondent first acquired land has to be identified. Then, my lord, from there, the portion which has not been acquired can be identified. The unacquired portion is to be subdivided among 3 co-sharers in the share. My lord, out of the 3 co-sharers, petitioner is the one of the co-sharer, my lord. Here, what they have done, they have filed the compliance. My lord, the order is passed on 13/12/2024. This order, my lord. On 27/11/2025, my lord has passed the rule. Thereafter, kindly see on 19/1/2026, they have given with the first notice last 3 days back. And what they have done in the paragraph 5 itself, they have mentioned no permanent reference point. They have not taken any revenue stone or something like that to demarcate the land. To demarcate the land, there should be some point from where they will start demarcation. They have not done. They have not, because in a hurry manner, they didn't get anything. They didn't get anything. So they have taken one measurement and they are saying, on the particular date, I was present, my lord. On 19th, I was present. But the first, what they have to do, the acquired land has to be shown to the acquired persons. That they have not done so. First, they have to show, because if they will give from anywhere the 200 square meter of land to the petitioner, there will be another issue. This will not settle, because the acquired land has to be settled. Then the 3 persons are left out. For them, they will, accordingly, they will demarcate and they will give me the 200 square meter of land which I am entitled. But they are not doing that, Your Honor. My lord.
All right.
My lord, kindly see page number
yes.
6, my lord. 6 of our affidavit of compliance.
Yes.
Page number 6, my lord.
Which page?
Page number 6, my lord. Annex F.
Yes.
Not para 3, my lord. However, in response to the notice of demarcation, attended the field and it was found that there no proper reference references was available, and the physical measurement was carried out on 19/1/26 in the presence of the petitioner by using electronic total station machine. The signature of the petitioner is also placed in compliance report. The petitioner was already informed on the field regarding continuous process of the demarcation. Further, the superimposing the field data on the revenue map provided by the Patwari, it was found that after acquiring the land area of 100 hectares of out of survey number 144 is presently available on ground, on which 2 semi-RCC building belongs to BC Seal and Susila Mandal respectively, and a portion of a tin shed which is under occupation of temple committee are standing, covering total area of 475 square meter. Accordingly, the petitioner was informed through the telephonically on 21/26 to attend the spot on 21/1/26 at 9:30 am after showing the boundaries as per the revenue record physically on ground out of survey number 144.
Yes, I have read it. Tell me one thing.
The next page, my
You
lord.
have acquired a particular plot of land.
My lord, the next
Are
page is
you
the map, my lord.
aware? Are you aware of the land that you have acquired? Or is it only book acquisition and physically you have not taken any steps to acquire it?
Map is on the next page, my lord, page number 7, my lord. The map.
Yes.
The boundaries of airport is there, my lord. The shaded one is the
Shaded one is the acquired land.
no, my lord. The other land belongs to the three petitioners, 3 persons.
3
144.
persons is the shaded land.
My lord. That is the area down, my lord, 0.2200 hectares out of
All right. So you say that the big chunk that is 144 is the land that is acquired by you.
my lord, airport authority, my lord. Yes, my lord. Airport authority. Yes. Airport by the
Airport authority.
airport
There
authority.
is a boundary line. Does the wall actually exist?
Yes, my lord.
So the wall is there.
Yes, my lord. We have also shown them, my lord.
All right. If the wall is there, then the petitioner's land can be identified properly. Then there will be no difficulty in identification of the petitioner's land. The total land of the 3 co-sharers.
My lord.
Then
Hello.
how is it that you could not find any revenue stone and anything for identification?
They are taking this airport boundary wall as a revenue stone.
Right.
And demarcating. That cannot be, my lord. Because in future, something happens, then my land again I'll be in dispute.
No, why in future they say that is the boundary line which they say as the revenue stone, or that is the demarcation, that is the point from where it will be taken up. So, your compliance report at page 6 says, second paragraph, verified the report of the Patwari.
Yes, but that is at
Which
page number-
reveals that the land bearing survey 144 has not been subdivided. Since the subdivided map is not available with the Patwari, demarcation is not able to conduct. However, Patwari. Now 144 is the petitioner's land also within 144.
144 oblique 2 oblique P, my lord. My land.
So there is
2 oblique
an
P.
subdivision oblique 2 is there.
My lord.
No, my lord.
Yes, my lord. In the order itself, it is there, my lord. My land is 144 oblique 2 oblique P, my lord.
P is part, my lord.
Where is in the sketch map, where is this 144 by 2? Please find it out, 1 minute.
My lord, it is not at subdivided, my lord. It is in the one.
But then কাল থেকে তো
Leave can be given.
And what is the urgency? Let me hear first. Let me finish this matter.
No,
Yes.
My lord, the last paragraph, my lord, a detailed sketch map showing the remaining area of survey number 144 has been prepared and enclosed herewith, which is the annexure 1, my lord. This is the page
Where
number.
is the petitioner's land 144 by 2? Where is that? Did you bifurcate 144? Where from is the petitioner getting 144 by 2? The airport line, see, please come to page 7.
Yes,
The
sir.
airport boundary wall is there.
Yes, my lord.
Left side there is 144, right side also 144. What does this mean?
My lord,
The boundary wall goes in between 144.
my lord, not subdivided, my lord.
Does it suggest that the boundary wall, the airport boundary wall, goes in between 144?
Yes, my lord.
No, my lord.
How can that be?
No.
Because not subdivided, my lord.
Very well, if it is non-subdivided, it is all right, but then you should know which portion of the land that you have acquired. What is that portion?
And they are acquired by the airport authority, my lord. This is the inside the boundary, in the left side.
Left side.
Yes,
Then the one in the right hand side,
yes.
outside portion,
Is the
this
available,
will be
my
the
lord.
petitioner's land.
My lord.
Have you stated that in so many words in the affidavit of compliance so that the petitioner gets to know that this is the portion which is left behind, not acquired by you?
In my order
Yes,
itself, my lord, page 15, para 6, they have filed the affidavit by saying that 144/2/P is there. Kindly see page para 6, my lord. An affidavit has been filed by the Tehsildar, signed on 13/12/2025, by mentioning that the writ petitioner is one of the joint recorded tenants in respect of land bearing survey number 144/2/P. They have not said 144. I have 144/2/P. That is the separate land, my lord. That is the separate land. And area about 0. They have filed this affidavit, my lord.
Yes.
After this, only this order has been passed, my lord.
Where is this portion? Are you representing the Tehsildar?
My lord, that's that. Is present.
Yes. Then where from does this 144/2/P comes?
Just to get rid from this contempt application, this type of compliance should not be filed, my lord. This is not appreciable, my lord.
Lord, it is not in marked. It is on the inside the 144, my lord.
Inside the?
144,
Inside 144.
my lord.
See, 144/2/P will certainly be a part of the
144.
motherland, that is 144/2.
My
This
lord.
mother number, right?
Yes, my lord.
So, is it your case that the portion in the right hand side of the boundary wall is 144/2? You've not mentioned that in your sketch map. How will the petitioner get to know that this is his land or her land?
After acquiring, this is the land available, my lord, on ground.
All right, this I understand, but where is this figure? And see, at the bottom of page 7
My lord.
of that sketch map, it is mentioned an area of 0 point something hectares out of survey 144 is presently available on the ground situated at Pahargaon, on which 2 semi-RCC buildings. That means the portion where it is line shaded
Yes, my
with
lord.
2 and a portion of tin shed covering area of such and such are standing.
My lord.
Is this the place which you are identifying as 144/2/P?
Yes.
Well,
And
then why have you not mentioned it in your sketch?
no separate map, subdivision map, not road. My lord, the instruction is that the subdivision map is not available, my lord.
How can the affidavit be filed in the writ petition that there is 144/2/P? You please check up your records. Come back on the next day.
My lord, we'll come back.
It should be reconciled. Where is the problem and how it is to be solved? Since you have acquired something, you must be knowing which portion is acquired. And the left must be that of the petitioners, the balance land.
My lord.
You are not required to identify the petitioner's land, but if you can identify your land, the portion that you have acquired, the balance is the petitioner's. It can be easily identifiable.
No, my lord, the airport authority is not the party. The Tehsildar is the party, my lord.
Airport authority is not the party.
The order says they have to give notice to them also, but they have not done so. It is there, my lord. Para 12, it is specifically mentioned. There is
Right,
a
necessary parties.
my lord.
Why don't you conduct fresh hearing by giving notice to the airport authority also, and then check their records? They must be knowing it well as to which portion is acquired,
My lord, we will
and
do.
you are beating around the bush. Please come.
My lord, we will come back.
Though an affidavit of compliance has been filed by the Tehsildar, but it appears that the order passed by the court has not been complied with till date. Passed by the court on 13th December 2024 has not been complied with till date. Stop. The court specifically directed the Tehsildar to conduct a spot inspection upon prior notice to all the necessary parties. Stop. It appears that the Tehsildar is taking the reference of a wall of the airport's authority, but no notice of hearing was issued upon the said authority. Stop. The matter relates to acquisition of a plot of land. Stop. The requiring body is an important party upon whom notice of hearing ought to have been issued. Stop. It is only in the presence of the said party that the Tehsildar will be able to identify and demarcate the portion of land which has been acquired. Stop. The Tehsildar is directed to take steps for immediate compliance of the direction passed on 13 December 24. Stop. The further affidavit of compliance shall be prepared and circulated by 27th February 2026. Release the matter on 12th March 2026. Tell me one thing, what was the Tehsildar doing for so many days? The order ought to have been complied long back, within a period of 4 months. 4 months expired when? Then why is the Tehsildar sleeping over the matter?
After contempt rule was issued, my lord, 3 days back only first notice was given, my lord. Till this time, more than 1 year they were sleeping, my lord. More than 1 year after passing the order.
What is the explanation? Have you given any explanation in the affidavit of compliance?
Oh, my lord.
Then I'm going to take your Tehsildar to task. Tell him to be extremely cautious, because the court is going to take a very stern view.
My lord, we apologize, my lord.
Your mere apology will not do. The order is required to be complied.
My lord, we will comply. Shall comply. My lord, today the appearance may be dismissed, my lord. Tehsildar
What is the name of the contemptor? Please put it down in the chat box.
My lord, the deponent, my lord, who has affirmed the affidavit of compliance today.
Is he Thomas Verghese?
Yes, my lord.
All right. Thomas Verghese, the contemptor, is personally present. Is present virtually. Stop. His personal appearance stands dispensed with for the time being. Do I direct him to come on the 12th of March? Otherwise, he will not be able to explain you properly. That do not dispense. The contemptor is directed to remain virtually present on the adjourned date.
My lord, may I submit, my lord, he is retiring on the 30th, my lord.
Is that the reason that he did not take steps?
No, my lord, not that. The
No, but
record
then
was
his
not-
retirement will not do. Contempt is going to take him to the grave also if the order is not complied.
Yes, my lord.
I'll add up the new ones, but he should remain. Let him come on the next day.
Highly obliged, my lord.
Obliged, my lord.
Yes, call item 2.
My lord, in item number 2, I am appearing for the applicant. My lord, a specific direction was given upon the contemner to file an supplementary affidavit by 18th of December. Only just an intimation that they have informed me that I have to file certain documents before the authority. For the same, till date, the contemners have not filed such
My
supplementary
lord, I am
affidavit.
seeking extension of time, my lord. The counsel representing the contemner due to personal difficulties not in station, my lord. I am seeking 1 week's extension of time, my lord, to file supplementary affidavit.
I will only make it not today.
Right.
I am not passing any order and no extension of time.
My lord, then Monday, my lord, please.
No, next Thursday it will be there, not Monday. Next
Yes.
Thursday it will be there. Thursdays I take up.
My
In the
lord,
meantime, you see how the order is to be complied.
my lord, we will file
All
our
right.
supplementary affidavit. Oblige, my lord.
Yes, not today, item 2. Yes, please.
Practically, if your lordship in real sense, that I cannot improve my case, that I cannot wait for 7 days or 10 days. This is he is the resident of the Hooghly, serving in the institute in the Kochbihar. To show your lordships can take up this matter here also. But sometimes there are.
What is the issue?
Issue is the matter of transfer.
No, then you can wait.
No, no,
Now I am taking up transfer matters of 2021,
No,
22.
I can wait, but let me have a
It
chance to file.
will create problem because from the next month there is a new circuit bench, new server and everything. So it's better. Transferring files from here will be difficult. Just wait for some time. Next circuit, you go and file it over there and get it done. All right.
Lordships,
Yes, for convenience. It is not for any other reason.
no, it can be taken up.
No, it's better you go over there.
Another circuit, your lordships can take up. The School Service Commission is the main respondent.
Yes, call.
Anyhow, your lordships.
Is anybody there?
I'm for the contemner, my lord.
Where is the petitioner? Has the order been complied?
No, my lord, the order has not been complied. My lord, the contemner is appearing in his person, my lord. She's
Where is
standing.
he?
Sorry?
Where is he or she or
She's standing outside. If your lordship allows me to kindly call her inside.
complied with?
I appear on behalf of the petitioner.
Yes.
But she's
But
the
not complied.
Order has not been complied. my lord.
Has the order been complied?
No, my lord.
No, my lord.
There is a direction for consideration or what?
No, my lord. Can you lord takes up your lordship's order is at page
18.
18, my lord.
Yes. Unauthorized construction.
Yes, my lord. Thereafter, my lord, kindly, my lord, may I place the order? My lord? I am of the opinion that the construction, my lord, the last paragraph, my lord.
Mm-hmm.
I am of the opinion that the construction could not have been made at the instance of the private respondent after rejection of their prayer by the learned civil court. The Gram Panchayat has also not issued any sanction for raising such construction. Learned advocate appearing on behalf of the private respondent relies upon a consent allegedly issued by the Gram Panchayat for making construction in September 2022. As it appears that the prayer for making necessary permission by the private respondent was rejected by the competent court, the Gram Panchayat could not have given any consent for making necessary repairs or construction. Gram Panchayat is directed to cause a spot inspection to ascertain the nature and extent of the unauthorized construction upon giving prior notice to the necessary parties.
Was this done?
No, my
Nothing.
lord.
Nothing.
The project Pradhan has
December 23 order was passed.
she assumed her office in August 2023, and she started taking up responsibility. She
21 আগস্ট আমি
This was communicated on.
Yes.
started off with her duty. She did not do anything, my lord. The order was not complied. It was a
Why?
mistake.
Why was it not complied?
ম্যাডাম 21 আগস্ট আমি জয়েন
Please
করেছিলাম
take instructions. He is not required to answer
She
the
shall
court.
comply, kindly give us for 2 weeks time, my lord. She will comply with the order and affidavit of compliance will be filed by us, my lord.
And
She will immediately take steps, my lord.
1 minute. 12 weeks time was granted for compliance, and
Compliance.
now you say you can do it within 2 weeks. So is she a superhuman or what? There must be a reason as to why 12 weeks was given.
Yes, my lord.
There is a requirement of issuing notice to the private respondents. You'll drag them. Come immediately, their notice is to be given. It has to be hard. This is how you'll function, isn't it? Then this is the way. And she took charge in August 23.
My lord.
And for these 2 years, she simply sat tight. Please come. নামটা লিখে নেবেন. Is personally present in response to the contempt rule issued. Why was nobody present on the last day? What was the reason as to why the rule had to be issued? Because nobody was present despite service?
My my senior Mr. Shomit Sharnal is the conducting advocate. He is not well, my lord. Due to that reason, he could not appear on that date, my lord.
He could not appear on that date. তারপর? Contempt rule. Stop. The order passed by the court way back on 5th of December 2023 has not been complied with till date. Stop. Learned advocate representing the contemner seeks time to comply the order and file the affidavit of compliance. Stop. In view of such submission, release the contempt application once again on 12th March 2026. An affidavit of compliance shall be made ready and circulated by 6th March 2026. Stop. Personal appearance, let her come
Yes.
the next day.
Yes, my lord. She will.
Which district? Which district is this? Which district? South 24 Parganas. Mograhat. For contemner shall remain personally present on the next date. Please make her understand what she is supposed to do. The civil court's order is there. She should take care. Yes.
This is my application, but with regard to the family pension. Then you will have disposed of the read, kindly come to page 14 of the application,
Yes.
para 4.
Yes.
Yes, my lord, your lordship's observation that learned advocate for the petitioners draws attentions of the court to averment made in para 8 of the deed petition and submits. The petitioner foregoes the notional benefit and only prays for issuance of the benefit on and from 8th of October, so and so the date of approval of appointment of the employee.
Yes.
Now, my lord, kindly come to page 6, para 12 of the petition. Page 6, my lord, para 12 of the petition.
Yes.
Well, your petitioners lastly had been to the district inspector of the school, Birbhum, on 13th of January 2020, when the said officer told that after giving notional benefit from so said, the pension papers should be prepared. But we have already foregoes the notional benefit, and your lordship has observed that. So what I'm praying from your lordship, that this should be directed, that without this notional benefit, my lord,
paragraph 4
your lordship has already seen that we
আপনার
have.
প্যারাগ্রাফ 4 এটা অ্যাড করতে বলুন
Are you representing the authority?
I am presenting the state, my lord. My lord,
State will include the authority.
yes
yes, my
The
lord,
pension sanctioning authority, the DI will be there.
yes,
Yes,
my
yes.
lord, since the
it was told that there were some corrections in the last order, my lord. If normal correction may be done, I have no objection. But if the court feels that something,
Listen, the court does not feel that the order is required to be corrected. What the petitioner is apprehending is that, and he has got to know from the authority over there, that as it is mentioned that the petitioner is not willing to take the notional benefit. Your client is forcing the petitioner to take notional benefit or what?
no,
I do not understand.
In that case, I need to take instructions, my lord. I have no instructions. my
The
lord.
petitioner has categorically mentioned that he or she does not want any notional benefit.
Yes.
All benefit from the date of his or her appointment should be given.
Digna.
Calculated that way.
My lord.
Yes, yes.
What
Take her.
the instruction is that no notional benefit shall be given. The petitioner has already foregone the notional benefit. Where is the question of granting notional benefit?
Very clearly, my lord, I have stated paragraph
Are
8 of the
Dikta
writ petition also.
Yes, yes.
Paragraph 8 is a writ petition.
Please come.
ওই ওটা থাক।
The
দেখে নাও, পড়ে দেখ,
ওটা ওটা দিচ্ছে না।
instant application has been filed
ওটা paragraph 4
in a disposed of writ petition for clarification of the order
আরে ওটা
dated 12th November 2025.
হ্যাঁ
Stop.
বাবা
It has been mentioned in paragraph 4 of the said order that the petitioner foregoes the notional benefit and prays for issuance of benefit on and from 8th October 2013, that is the date of approval of appointment of the employee. Stop. Paragraph. The aforesaid recording makes it extremely clear that there is no question of grant of any notional benefit to the employee. Stop. The pension sanctioning authority shall make necessary calculation of the terminal dues of the employee on and from the date of approval of his appointment, that is from 8th October 2013. There is no reason for calculating any notional benefit for the employee. Stop. Next. Can the
yes yes
connected application
yes
discuss?
yes
My lord, the
Can we
date
dispose?
may be
No, no,
It is
already
already there.
all the well,
yes the application is disposed of
12 weeks, my lord has
12
said.
weeks is already
12
there.
weeks, my lord.
The can disposal এর আগে the authorities shall take steps strictly within the time limit as mentioned in the order dated 12th November 2025.
get to
Connecting application disposed of.
My lord.
ফেরত দিয়ে দিন, লাগবে না। Record the name of the respondents.
Twenty-three to 84 to 286
West Bank matter also we recall where the bank was not allowing the banking operation by the directors of the company on the pretext that the bank has to.
This is actually my application.
There is some developments.
I'll indicate. After all, it's three applications have come up. This will take some time. It had gone. Your Lordship's order that was passed was carried in appeal by them before the Honorable Division Bench.
Kindly takes a look at
Division Bench has passed an order. If kindly keeps it on next Thursday, this will really take some time.
The division bench order. Very little remains after the division bench.
Yes, no, that's not true.
The
We know
Lordship's
it has
order,
been argued.
I know it's been clarified at the end that this is
Respondents, there are two applications. One by
kindly takes a look at takes a look at page 18 of the judgment so far as the bank is both
Are you representing the bank?
So I am for the writ petitioner.
Let
I am
him
the
raise my case.
petition.
Bank.
It's bank. I am for the bank, Millard. There's a bank
Axis
application.
Bank.
Axis
There's a
Bank.
clarification. I
By
have
the bank.
yes by the bank.
And my recalling application is pending. These are my recalling applications.
On
Who
the
is the writ petitioner?
I am
Mr.
the writ
Mitro.
petitioner.
He
The
gets an order
company.
from your lordship.
Well, why they have
Because my application.
my
has
writ
come up.
petition.
Because then I file an application for recalling of that.
Are
order.
you a party in the writ petition?
Oh,
He has
We
not
seek
been
an
better.
increase
and
in
the division bench found they have no locus standi.
No,
They have
that's
no
not
locus.
it. That impleadment application was allowed. The order that your lordship had passed in writ petition was stayed. Carrying this was carried in appeal. In the appeal, this order has been passed now. Mr. Mitra's reading is nothing is left. The order I have read it differently because the order record that this will not affect the
All right.
disposal.
Now, what is the stand of the bank?
Two sentences. Millard did not challenge the order. Bank wanted to comply. Millard, there was an indemnity to be provided by Mr. Mitro's client. Bank has a standard form of indemnity, Millard, under 126 of the Contract Act. They say no, these clauses we do not want. So Millard, there was negotiation was going on. They gave a bank guarantee that has still not been executed. Secondly, bank said Millard, under Millard the banking regulations, Millard, which I'll point out if in the next date, Millard is a change of signatory, Millard. Then well, naturally a corollary order has to be there. That's my sum and I want to comply. I only want the lordship will say there are two conflicting Millard bodies are fighting. Bank is caught Millard in between them. There are two bodies.
Para 40,
Millard, I do not.
40
I never. Millard, this cannot continue.
paragraph, lordship kindly
Please,
listen.
Millard, you will not allow anyone to.
You will
speak.
not allow the court to see the order. Para
बोलते देवे ना
40.
आपकी बोलो
Para
let him
40,
finish Millard. Lordship there are
41, 42. Lordship kindly
if he is so eager
Para
Millard,
40, it is none of the business of Axis Bank in its capacity as the banker of the appellant number one to peep into the internal affairs of the company in the teeth of the unmarking of
Millard,
the
he has
number
not
two as the management dispute.
Millard, the main
In view
order
of the
has not been
NCLT order
challenged.
with substance whereby respond numbers 5 to 7 do not have any locus standi as any functionary of the appellant to
Give it
raise
last
any objection to the operation of the account. Then para 41, they are the interviewer, Mr. Suryakanto Banerjee. The third important aspect of the matter which disturbs the court is that the second rehearsal, Oshishi kindly turns the page. Page 18, the third, sixth, seventh line. Thus, not only has sufficient safeguards been incorporated in the writ court's original order by directing VTL to grant the indemnity, it is evident that VTL itself, on whose letter the bank froze the account in the first place, has taken a stand supporting the defreezing of the account. Thus, no impediment can now remain in the path of the bank to defreeze the account pursuant to the order of the writ court, since the very premise of its freezing has now been erased by VTL itself coming up in support of the defreezing. 42. Accordingly, the clarification sought by the bank is prima facie moonshine. In an unwarranted bid to thwart the operation of the respondent of the account and the process to put a spanner in the wheels of implementing the original order of the writ court, now sought to be recalled in an apparent act of camaraderie with the respondent numbers 5 to 7, in tandem with the APL committee appointed initially by the trial court. Furthermore, the respondent numbers 5 to 7 have been denuded of the locus standi to interfere in the affairs of the company by virtue of the NCLT order, does not have any right to be impleaded in the writ petition at all. Even otherwise, in view of the division bench judgment of this court in the testamentary suit, estate of the late PDB has been restricted only to her direct shareholding and the incidents thereof, thereby taking the appellant number 2, where she did not have any significant shareholding outside the ambit of her estate, to be administered by the APL. Hence, the challenge by the APL against the removal of R5 to R7 is a cause of action exploited by the APL itself and not on behalf of respondent numbers 5 to 7 in the capacity as director. The respondent numbers 5 to 7 cannot piggyback on the APL challenge to claim locus in view of themselves having not taken out any challenge. Now, Lordship kindly comes to see what is in their favor.
Para 50
para 45 was well, para 45
look at para 40,
para
50
45 was.
Just
Even
just
otherwise,
frame
the
it.
remedy of this 5 to 7, if any, 45, could at best lie by way of an appeal before the division bench of against the parent order passed by the writ court with leave to prefer such appeal. Having not been parties to original writ petition, the law does not contemplate an application for recall simpliciter in a disposed of writ petition, particularly since that the dismissal was on the merits of the case. No case of review or order has been made out in the recall application, nor has any other justification been given to recall the order. Hence, prima facie, the recall application as well as the clarification application not maintainable in the eye of law. Now, Lordship, what is in their favor, which they are
kindly will
with
take
the harping
paragraph
on,
50.
is that para 49 and 50.
No, para 49,
49 and
50 and
50 is
52,
what-
Mr. Mitro.
what
Miller,
has-
it's my application,
kept-
Miller, is first
has
on
the
board. I have a right of
49 and
hearing,
50.
Miller. That's paragraph 50, Miller.
But whatever the application is for.
Miller, the problem, let me, Miller, address my application.
50 to 53, please have a look at.
Kindly have a look at 49,
I said
50
49 and 50
and
are the
52.
ones which
Kindly have a look at it. Kindly have a look at it.
53 is the most questionable.
Yes. Kindly also have a look at, Miller. 50, Miller. The learned single judge is requested to take up all pending application together as per the convenience of the bench by disposing of the recall application respond numbers 5 to 7 and the clarification application filed by Axis Bank first, and thereafter to decide the contempt application subject to the outcome of the recall application. The Miller kindly takes 52. We hasten to add that the court has not decided on merits of the issues involved in the application pending before the writ court, and all the observation tentative in nature and only conclusive at disposal of the present appeal and the connected application is concerned, and the finding observations of the court shall not in any manner prejudice the rights and contention of the parties in the pending application before the learned single.
So, Milord, there are 3 applications which your lordship needs to decide.
3 Millard by Millard by the Millard.
2 by us, 1 by the
Yes,
bank.
yes.
Bank, Milord, 1 by us and 1 by the bank.
Bank.
One in each of
Milord,
them.
this
One in each of the weeks.
Dada, Dada, you bole nahi. Now, my lord, these applications, my lord, kindly fixes a date and hears them out whenever your lordship pleases. Dada, you haven't gone there.
There's a direction paragraph. There's a request. Para 50.
Few more months.
I leave it to your lordship, Millard. Whenever principal order remains, I am to comply with. He has to sign an indemnity. He has not gone to Millard court. He has not gone to appeal court challenging the main order that he does not require to execute indemnity.
Complies with your lordship's order, subject to Millard, my applications being heard.
It's recorded. I want to
Kindly, Millard,
comply with
here's
your
my application any day your lordship feels, and Millard, your lordship decides it on that very day.
Correct.
Itself. There is no problem. That's up to your lordship, Millard.
Today there is an early rising.
Yes.
Only not
Any
today.
day your lordship feels.
Not today. Let it remain in the list in the same position as
Can it be on the
May I just
can it be on the 5th Millard? Can
Yes,
it
Millard,
be
that's
on the
one-
5th Millard?
exactly.
That's my request.
It's
Millard.
on, if it could be. on
It's my
20th,
application. I have to move it with first in board Millard.
সারা জীবনের পরে করো না তো এতক্ষণ ধরে
No, my lord, Lordship, let it retain the position next day.
I leave it to your lordship. 5th will be convenient.
Hopefully, there
for
will
me,
not be
yes,
a
I-
vacancy next day. We shall do.
I am in some
If
Millard.
it could be on the
in
5th.
case it is difficult, make a prayer. We'll see how to
I have got
when and how to accommodate. Because in the interregnum there is only one day, that is 29th, and then is the 5th.
5th. That's why I said 5th.
If
I said
29th
5th Millard because that.
it's all right, then it's all right. Otherwise on 5th.
Otherwise, but the bank can make the submissions, Lordship, after all.
On the 5th Millard.
He has a difficulty on the 29th.
I am making 5th Millard. I am saying 5th.
I am sure there will be a problem on 29.
Sure.
29, that's Thursday.
I am saying Millard 5th Millard.
5th.
I have an
Mr.
instruction from Millard, the outside
Mr.
council
Matter on
Millard
5th.
coming.
Very good.
Great for the same position on 5th, but same.
Yes, yes, yes.
I'm grateful to God.
Grateful.
লিস্টের নিচে লিখে দেবেন তো 5th। লিস্টের নিচে 5th লিখে দেবেন।
Grateful.
লিখে দেবেন 5th। ডায়েরিতে লিখে নিন 5th। সেম সেম সবই সেম দেখছেন না নাম? হ্যাঁ 286 ও সেম, এবার 287 হবে। Call 287.
My lord, I beg to appear on behalf of the petitioner, my lord. The order has not been complied.
Lordship, 287, previously, affidavit of compliance was filed. Your Lordship was not satisfied with it. Thereafter, an appeal has been preferred, very much in the knowledge, but though it has not yet been taken up for hearing, it is appearing before the division bench, and I've brought the case. This is the predicament, Your Lordship. It has.
What is the predicament? Your filing appeal is a predicament.
Your Lordship,
Then
appeal is pending. I pray for a
it's predicament.
Your Lordship, I pray for a deferment for a considerable amount of time, so the appeal and the stay application may be heard out.
The appeal is not admitted yet.
What was the direction? Necessary correction in the record of rights.
My lord.
What was to be corrected? Record of rights correction. In
My lord.
terms of what? Civil code?
Civil code. Now the difficulty is, Your Lordship, civil court, the state stand is that the civil court ought not to have entertained that suit. And an appeal was preferred by the Zilla Parishad that was dismissed for default before the learned court below. Now they have cited in the compliance report and in the reasoned order, in compliance of this court's order that they have passed, they have cited a set of judgments which says that if
Judgments will not do.
Your Lordship, we understand that's why it is before the appeal.
As long as an order remains, despite the same being not in accordance with law, it has to be complied. You cannot overtake or bypass or do anything. You have to do it.
At least
Now it is your responsibility to take up the appeal.
Lordship,
Urgent basis.
that since I am not appearing in the
That is
appeal,
not
we have
seen
that's
by
why
this
I'm praying
bench.
for deferment of this.
My lord,
contempt
even they have
application for
not
a
taken
considerable
pain
amount
to
of
mention
time.
the matter before. My lord, I
Your Lordship,
humbly,
on
I
the last
humbly prayed
occasion,
for
my
it.
learned friend hasn't even submitted that the appeal was pending. He has submitted his wakalatnama.
Why will he submit?
Your Lordship, kindly consider.
It is your appeal, you
kindly,
submit.
kindly defers this for a considerable amount of time.
My
By
lord, this
that
is the order of
time,
2024, my lord.
done, then
I humbly request for
because
issuance
I
of
have
rule, my lord.
personally requested the state authorities
Issuance
to
of rule. Then what will you do with the rule?
Your
So
lordship.
what will you do? You tell, I'll issue the rule. Then what is to be done? You think the order will be complied if the rule is issued?
No, my lord. There is a specific direction by DLRO that is on the last.
Why are you making submission for issuance of the rule?
The alleged contempt should be brought before your lordship.
Yes, and then put to prison.
I'm sorry.
What do you want?
Correction of the record of right.
And he'll sit in prison and correct your record of rights.
No, my lord.
You should know
My lord.
how much to speak.
My lord.
What is the date of the order?
Page number 116. 9th April 2024.
page 7 of my affidavit of compliance. And in
The order is of 9th April 2024, my lord.
Rely upon a judgment of the Honorable Supreme Court, Your Lordship.
What does it say?
In respect of deferment, the application for stay should be given preference. If Your Lordship kindly sees paragraph
Application
6 and
You move the application for stay.
Lordship.
Who's stopping you? Nobody is stopping you. You take steps.
Gives a considerable amount of time so that
Considerable amount of time means what?
Lordship, I am not there in the.
What? 5 years plan? Then what?
Your Lordship kindly defers this for a.
What is the date of the order?
Of the
9th
order
April
concern is, Your
2024, my
Lordship,
lord.
9th April 2024. And
That is
thereafter, an order was
9th
passed.
April.
Rightly or wrongly, an order was also passed.
See, 9th April 24. Today we will be approaching April 26 very soon.
Lordship, in my humble
The order
understanding,
dated 9th April 2024 has not been complied till date. Step. Learned advocate representing the contemner submits upon instruction that an appeal has been carried from the order passed by the court which is pending disposal before the Honorable Division Bench. Step. Prayer has been made to defer hearing of the contempt application. Step. Paragraph. As it appears that a considerable period of time has elapsed from the date of the order, the court is not inclined to defer hearing of the matter all over again. Step. The application for contempt was filed on 19th of November 2024. Step. Had the contemner been aggrieved by the order passed, then prompt necessary steps ought to have been taken to obtain an order from the Honorable Division Bench. Step. When was the appeal filed?
Correct
In November 2025, Your Lordship.
November 25.
November 25.
After
By
vacation.
It has been submitted that
And in
the appeal has been
contempt
filed
proceeding, we have passed
only
order.
in November 2025. Section 5?
There is section
Go
5.
to that, I do not have any.
Nothing.
Section.
Yes, sir. Next. The court does not appreciate the stand of the contemner and the speed in which they are moving to challenge the order passed by the bench. Stop. Next. The contempt application stands adjourned till 19th of March 2026. Stop. An affidavit of compliance shall positively be filed prior to the adjourned date.
Thank you. In position, my lord, on the next day.
What is your item number today? What is it? 288? What is it?
The violation of the order, Mala, kindly see.
280.
Yes.
IAP of the alleged contempt as in item 288.
This matter?
Yes.
All right.
My lord. Because of this order, my lord, they are violating, they are not complied with, they are making construction. And last Thursday it was heard, directed to serve the notice to the
Take it
corporation.
to 88. Take it to 88.
Last Thursday কি হয়েছে লাস্ট থার্সডে হয়েছে না 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 আমি সেই অফিসার ইনচার্জ কর্পোরেশন ছিল বোধহয় লাস্ট থার্সডে আবার কোনো অর্ডার হয়েছে হ্যাঁ আচ্ছা নোটিশ দিয়েছো
Mala,
last
kindly see,
Thursday?
the order.
না না ওরকম করেই করে ভুলভাল সব
December 2023.
7th August 2025.
I thought again notice to the corporation also.
My lord, corporation is here, my lord.
Unauthorized construction was.
My lord, we have, my lord, complied with your lordship order entirely, my lord. If your lordship kindly sees, and my lord, kindly permit me to, my lord, describe the conduct of the petitioner. My lord, this petitioner is claiming, having a claim in respect of mutation in the property in question.
No, you tell me how.
My lord, 1 minute, my lord, my lord. He failed severely before the writ court, appeal court, my lord, he failed. As a, my lord, parallel, my lord,
Why are you making this submission? I want to know what is the steps you have taken to deal
my lord,
with
we
the
have
unauthorized
initiated
construction.
proceeding, we have concluded there is a, my lord, connecting, my lord, slab in between two staircase for, my lord, emergency exit. We have, my lord, regularized it. My lord, subject to payment, SOB has passed an order. If your lordship kindly says entirely complied with. And as a parallel, my lord, proceeding, my lord, he is just filed this chancy petition claiming unauthorized construction. That is not there.
That is not there.
D sketch map I have also given. If your lordship kindly sees the SOP's order. This is a platform in between two staircase.
Did you communicate this to the
That is also appearing in the report itself. Your lordship kindly sees the first page.
Yes, this sketch plan was communicated to the person responsible for making construction. What about him?
I'm giving it to
Obviously, you should give him.
Yes. He is having some other agenda, fighting in between the parties in different other proceedings.
Court is not concerned.
My lord.
You are also not concerned.
My lord.
So what is the use of making this submission? Your officers also have some agenda. Will you make further submission?
Because my lord, he also filed a proceeding claiming my lord, mutation in respect of that property in his name. My lord, that has already been failed. My lord, my officers all.
You are the corporation. How are you involved in between the infighting between private parties?
My lord.
6th of May 2025. 401. Take a copy of this order. An order has been passed under section 401. Please come. Learned advocate representing the contemner / corporation produces copy of the order signed on 16th of July 2024.
It's
Compliance of the order dated.
No, this will be order.
I have to take instruction.
Whereby order has been passed under section 400 within bracket 1 of the KMC Act 1980. Stop. Let a copy of this order be handed over to the learned advocate representing the petitioner. Stop. As the order is an appealable one, comma, any person aggrieved by the same may prefer an appeal before the competent forum in accordance with law. Stop. Contempt application stands disposed of.
Good.
আমি দিয়ে দিয়েছি স্টে ঠিক আছে